Hi, it's Injury Attorney Ann Fong, and this is what you need to know. We're going to talk about litigation a little bit more and some things that happen during litigation. At some point, your attorney may advise you that the parties may want to go to what's called mediation. And what that is it's a little informal process where both parties meet and they have a neutral mediator. That is normally somebody who is experienced, retired attorney, maybe even a retired judge. Both parties have submit a mediation brief beforehand, facts about what happened, and then the mediator's goal is to try and help settle the case. And normally what that comes down to is the monetary amount of what the case should settle for. And normally there isn't so much one side that wins and is like, hey, yes, I won a great deal. Normally what happens in mediation is both parties are giving in a little bit, and not one party's going to walk away with too much, of a feeling of, yay, I won one over them. But they're sacrificing and they're saying, hey, I've evaluated my case. Maybe it's not as good as I thought. Maybe there's more issues that I thought. And so, but there's a number that makes sense, that works for the client as well. And so sometimes cases do get settled at mediation, and sometimes they don't. And you have the ability, what's great about a mediation is you have the ability to walk away from the mediation, and nothing that was said, any kind of negotiations that happens in the mediation can be used later on. So you don't have to stick to a certain number, a certain bottom line or anything like that. So it could be an effective tool to help you settle a case. If you ever find that you want to have an option of a mediation, talk to your attorney about it. Make sure that all options are available to you. And that's what you need to know.